Next, from the House chamber, the House takes up debate on the concealed carry bill, which would allow for the carrying of a concealed weapon in Illinois. Currently, Illinois is the only state in the nation not to have a concealed carry law. This runs about 55 minutes.
We believe we made a lot of necessary changes to make this bill the best bill that we've had in a long time. Here, let's back up and revisit to where we're at today and why we're doing this and why we need to do this. December 7th, the 7th Circuit of Appeals came down with a very harsh mandate that said we must pass something reasonable within 180 days. It also said that Illinois' ban on concealed carry is unconstitutional. So they gave us 180 days, and the cliff, as we call it, is June the 9th. So if we do not pass something reasonable, which we think we have here in Amendment 9, constitutional carry could set in, meaning that if you have a valid Ford card in the state of Illinois, you will be able to carry anything you want, wherever you want. And I don't think a lot of people that are planning on voting no on this evening understand what that means. So to protect your districts, I would say let's get on board, because this could be our last chance to passing something by June the 9th. And there's too much uncertainty, so that's something each and every one of you need to think about tonight if you're planning on voting no on this amendment. I ask for this passage.
Mr. Phelps, the chair is reelected. We're going to adopt the amendment and then take this right to third reading. Those in favor of the amendment say yes. Opposed, no. The ayes have it. The amendment is adopted. Mr. Clerk.
No further amendments have been approved for consideration. No motions are filed.
Third reading. Mr. Clerk, please read the bill.
House Bill 997, a bill for an act concerning firearms. Third reading of this House bill.
The sponsors already explained the bill. The amendment became the bill. By agreement between both sides of the aisle, there will be 8 speakers. The speakers have already been chosen. I will tell you who the speakers are. These will be the only 8 speakers we have. The Democrats will be Representatives Zaleski, Cassidy, Costello, and Martino, with Mr. Phelps to close. The Republicans will be Mr. Kay, Eunice, Meyer, and Bost. The first speaker is Representative Zaleski.
Thank you, Mr. Speaker. Will the sponsor you up?
Sponsor yields.
Okay. Thank you, Mr. Speaker. And Representative, I mean, we've talked about this issue, and there's nothing I'm going to ask you that's meant to disparage your hard work on this or in any way do anything other than flesh out what's before the body. So at the outset, I want to say this, but I want to first talk about the penalties within the bill with respect to what happens if this bill were enacted. Can you explain to me what the penalty would be if a person were to carry a weapon within a prohibited area?
Yes, thank you, Representative. I know we've talked about this before. So the first offense is a Class B, and then the second offense is Class A, and then finally the third offense would be revocation of the permit, the concealed carry permit.
So under current law, and correct me if I'm wrong, but under current law, if a person has a firearm on their person and they're in a prohibited area such as a school, a park, a mass transit, wherever, what are they guilty of under current law?
On the UUW would be Class A misdemeanor.
And what if they have a prohibiting factor such as they have a prior felony in their background? What are they guilty of then?
Yeah, it's Class 4 felony.
Class 4. So, in effect, we are rolling back the penalty enhancement, or the penalty of carrying a weapon with the enactment of your bill for a first-time offender.
Well, the thing about this, though, Representative, is that felons are not going to be able to have a concealed carry permit to begin with.
I understand. Brandon,
or a Ford card, for that matter.
So, but my question is, we're going from under what you just said, a Class A misdemeanor to a Class B misdemeanor.
Yeah, Class B, Class A, third offense is revocation. Because remember, the bad guys already have the guns. we're setting up parameters with this and making sure the good guys have the guns. And, you know, with the people that's going to be vetted to try to get this into the training and try to get this permit, they're going to have the training, they're going to have the background checks, more than one, because number one, to get the permit, you got to have a background check for that. To get the gun, you got to have another background check, and then the state police does another background check. So we've got more background checks than any other shell issue in the country.
To my next question, Representative, tell me the status of a person with an out-of-state carry permit under your bill.
It's we got different states in there. We are going to allow reciprocity with a few, not all states: Arizona, California, Florida, Iowa, Kentucky, Michigan, Minnesota, Missouri, New Mexico, Ohio, Tennessee, Texas, and Wisconsin. And I believe that is reciprocal to a Florida license.
Representative, are you sure about that?
It's because the reason why we did that is because they have similar training to what we're trying to do. And they also go through background checks like we're trying to do.
And Representative, okay, well, we get to that question. Some states have fewer training hours than other states, correct?
Absolutely.
So, for instance, Utah, what is their training requirement?
4. And that's what we started out with, Representative, as you know, was 4 a while back.
But you bumped it up to 8, right?
We went from 4 to 6 to 8, and now we have 8 with the live fire exercise. So we think it's going to be 10, and that's the intent.
So why would someone in Utah have to have fewer training hours than someone in Illinois? First, I mean, why would we want to have our citizens train more than the person from Utah?
Because there are legislators on our side more than anybody, Representative Zalewski, that wanted more hours of training because they said that would make a difference for them to vote on this. We've always given, as you know, we have worked on this very hard and tried to come up with the best concealed carry bill we have, and I got to say, I've read a lot of them. This is the best one that we think we have.
Well, I think Representative, I commend you on how far you've come. There's some questions we have. I mean, on page 19, line 23, what I read is those states with substantially similar laws include but are not limited to Arizona, California, Florida, Iowa, Kentucky, Michigan, Minnesota, Missouri, New Mexico, Ohio, Tennessee, with Texas, and Wisconsin.
There's mainly 2 types of permits out there that a lot of people get, and a lot of people from our own state have. One's Florida, one's Utah. We are not going to recognize Utah because we don't think that they have a sufficient amount of training. Therefore, if they want Illinois, they're going to have to apply for it.
But to my question, Brandon, you said a minute ago you limit it to those states, and the language says substantially similar to, and they're not limited to those states. So can you clear up that discrepancy?
Yeah, the state police does that, Representative, to set up reciprocal agreements.
Okay. My next question, Representative, is with respect to
I wish you would have brought these up before. I never heard you talk about these,
I know,
Mike.
Representative, I understand. Local law enforcement. Under your bill, could you describe for us the process if a local law enforcement has an objection to someone having a permit?
Yeah, local law enforcement and local sheriffs, and I want everybody to pay attention to this because this is a safeguard we put in. Local law enforcement and local sheriff's offices can flag or file an objection on anybody that they know of that they don't think should have a concealed carry permit. But we put that safeguard in there because we believe that a lot of local law enforcement and local sheriffs know the people in their areas better, so we allowed that to, actually for some of us we didn't want that, but we thought that would be a safeguard because we're trying to make this bill as reasonable as we can.
Under your bill, the objection by local law enforcement has to be connected to physically attached to the application?
Yeah, correct.
So who, and I'm not asking to be glib here, who would apply for a permit and first go to their local sheriff or police superintendent and say, can you tell me if you object to my application before I apply?
The way we understand that, Representative, is that state police would contact you if you had tried to file an application. You may not know that the local law enforcement and sheriff is going to object to your issuance, so therefore you would probably get contacted by the state police.
No, but I mean, the language says they has to be attached to the application. So why would someone applying for what would induce someone to say, I want to apply for this? I'm going to go first, see if there's any objection from my local law enforcement official. It's not a question of people that don't abide by the law. I don't know that law-abiding people would want to go through that bureaucracy. Why do you do it that way in the bill?
It may be in the drafting area, Representative. I see what you're saying, but I mean that's not the intent. I mean,
okay. All right. I mean, I understand. The next question I have is the state police. They're the it's yours is a shall issue bill, correct?
Correct.
The state police is the issuing agency.
State police is the issuing agency.
They, under your bill, if there's an objection, if the person wants if the person manages to get the application in and has the objection with it, submits it to the state police doesn't have to consider that objection, correct?
Yeah, that's correct. They do not have to. It's at their discretion.
Brandon, would you give any thought to asking the state police to compel them to consider the objection? I mean, if this local law enforcement agency has that much of a concern, why shouldn't the state police have to consider that?
Yeah, we don't want to give complete discretion to a full body without.
And that's fair. That's fair enough. I mean, I guess I would say is if there's an objection and we want the state police to consider these objections, giving them discretion is what some of us would consider to be is reasonable.
I don't think there's very many states in the country. Remember, we're the last ones. Everybody remember that. Illinois, we're the last ones to have concealed carry. I don't think there's any of those safeguards that allows local law enforcement to object in most other states. Yes, because remember, the more discretion you have, this turns into a May issue, and you saw what May issue happened yesterday.
No, and I understand, and I'm not trying to represent. I have a couple more questions, and I'll wrap up. In your bill, if a local municipality decides to implement more restrictive measures, what effect does your bill have on a municipality's ability to regulate its firearms?
And this is a big issue because number one or number two, either way you want to rank these, shall versus may and preemption. We want preemption because we believe in what Judge Posner believes in the Seventh Circuit, that there should be one uniform law that everybody knows about, and therefore that's why we don't want to give up preemption. So in your bill, there would be no ability for a home rule unit to have any say over anything with respect to firearms? There's limited authority by local governments, is what I'm being told, but also to control their own property, control their own property. For example, like City Hall, so to speak, can't go in, can't carry in there. But we just believe there should be one uniform law because we think that we would make law-abiding gun owners criminals because he or she are not going to be able to, when they travel around different towns, know what that ordinance is, and you're making law-abiding gun owners criminals, and we don't think that's right. No, and I don't think it's right. I mean, I don't think it's right either, but we're trying to resolve some of the concerns some of us have. What happens if a person... what is the liability a person has, say, a homeowner, a business entity, a college, university, if they decide they wish not to have someone possess on their property? Yeah, there's nothing in the bill that relates to their liability. There's civil immunity, but any entity that permits carry on its premises is granted immunity from all civil suit based on its decision. So anything that happens, the owner of that property is immune from civil liability. Yes.
Can you explain why that's a good policy judgment?
Mr. Zaleski, after this question, can you bring your remarks to a
will.
close, sir? Thank you.
What, I'm sorry, Mike, what'd you say?
Why is that a good policy judgment?
Because that's what some legislators wanted. They wanted to be able to take that liability off of the business owner and homeowner and things like that.
So
So that's why we did that. We were asked to put that in because, like I said, this has been a this has been worked on for many, many years and many different versions.
Thank you, Brandon. I'll bring my remarks to a close and speak to the bill. There's some things that I think if we could just tighten up within the constructs of your bill, and I tried to go through some of them, I would support your bill. I mean, I asked maybe 5 minutes of questions, and there are things that can be easily resolved. And then I think you'd have the necessary votes to comply with the judge's order and give your constituents and law-abiding gun owners the desire, their wish to carry and to protect themselves and to assert their Second Amendment right. And we're almost there, in my opinion. I just wish we could address those concerns. So thank you for answering my questions, Brandon.
Ladies and gentlemen, I'm going to begin to use the 5-minute timer. The next speaker is Mr. Kay for 5 minutes.
Thank you, Mr. Speaker. To the bill, we have had a lot of debate in here about legal aspects of this particular issue. And I want to clear up some misconceptions so we're dealing with the truth and we have a clear understanding of just what we're considering today. Yesterday's debate, as I understand it, made reference to a denial of certiorari for a New York concealed law under a case which is known as Kukalski versus Casey. A 1995 U.S. Supreme Court decision of Missouri versus Jenkins, the denial of cert, as I understand it, means that no binding procedure is created by the denial of itself, and that the lower court's decision is treated as mandatory authority only when the region of jurisdiction of that court, in this case the New York Court of Appeals, and that has absolutely, that is the New York case, has no bearing on what we're doing in Illinois. So let's not confuse ourselves. What applies to the East Coast doesn't apply to the state of Illinois. We need to be very clear about that. We need to be sure that we understand what's correct. We need to be sure that as we debate this bill and we listen to where we are today, that short of an in-flight claim, there is no appeal by the state of Illinois for a for hearing. So accordingly, what we have today is a final and binding decision upon us, which I think the representative carrying this amendment made reference to. Technically, the Seventh Circuit is not pending, it's final, because the Attorney General of the state of Illinois has not elected to run the issue any further. Therefore, let's be real clear. Here's the truth about where we find ourselves today, and I want to just read from the decision that came out of the Seventh Circuit.
Ladies and gentlemen, excuse me, Mr. Kay. Yes. Ladies and gentlemen, it's a very serious issue. Many people have been waiting to debate this for some time. Let's keep the noise down. Let's finish this debate and move on with the rest of our business. Please. Please, ladies and gentlemen, please. Mr. Kay.
Thank you, Speaker. So here is the truth based upon what the court said, not what I say, not what any of the rest of us say. This is the law that's been handed down. Now, let me just read a part of it. We are disinclined to engage in another round of historical analysis to determine whether 18th century America understood the Second Amendment to include a right to bear guns outside the home. The Supreme Court has decided that the amendment confers a right to bear arms for self-defense, which is as important outside the home as inside. The theoretical and empirical evidence, which overall is inconclusive, is consistent with concluding that the right to carry firearms in public may promote self-defense. Illinois had to provide us with more than merely a rational basis for believing that it is uniquely sweeping ban is justified by an increase in public safety. It has failed to meet the burden. Repeat that. It has failed to meet the burden. The Supreme Court's interpretation of the Second Amendment therefore compels us to reverse the decision in two cases before us and remand them to the respective district courts. Ladies and gentlemen, the court has clearly, without any ambiguity, has told us what we must do. For years, we have been denied our Second Amendment rights. And the court has given us 180 days to fix it. And we've had one debate after another with some good information and with some very bad information. The court has ruled. Let me just say this. If we do not decide this issue, it will be decided for us, and those who have worked on UUW in this state for many years to, first of all, put it in place and then enhance it, will have gone to waste. We will allow things that don't want to happen in this state if we do not act today. We don't want people carrying grenades. We don't want people carrying very destructive devices that are used in war. That's why we have a UUW law. Ladies and gentlemen, the truth is just this. We've been asked by a court, based on the decision that I just read, based on their finding that we have violated the Second Amendment in the state of Illinois, to get busy and construct a bill. What the representative has brought us today, what Mr. Phelps has delivered, is precisely what the court has asked us to do. No longer can we deny the constitutional right of the Second Amendment. No longer. Some may dislike that. Some may find it very pleasing that the court has come down on our side. But make no mistake, this is the time that we make a decision. We understand that there's some restrictions may be needed. The representative has dealt with that. There may be some things that we like and some that we don't. But make no mistake, the truth is that the court has told us that the time has run out and we have to act. Thank you, Mr. Speaker.
Chair recognizes Mr. Costello. For 5 minutes.
Thank you, Mr. Speaker. Will the sponsor yield?
Gentleman yields.
Mr. Phelps, could you quickly explain the mental health component of this bill, the changes that have taken place?
Yeah, thanks, Representative. And I want to thank you for many hours that you've helped on this as well. But we moved the fee up. If you remember, ladies and gentlemen, we had it first at $25. We moved it to $80. Now we have it to $100. And let me explain this about because this is the first time we've ever done this. We are allowing $70 of the $100 to go to the Illinois State Police to administer this program. We're also doing something new, which a lot of you wanted. We are taking $30 and putting it in, creating a fund where it helps our mental health reporting that is a travesty right now today, as all of you will agree. So we are trying to help the mental health reporting. We're going to try to help speed up the FOID cards right now because there's not a lot of FOID cards being given out timely. So we think we have a good model on the fees. Okay, and then the training we've had from 4 hours to 6 hours to 8 hours, and now we have 8 hours plus live exercise, live fire exercise, which we think it'll be a total of 10. So we moved that up, and the penalties, which I know Representative wanted, we upped the penalties because before they were petty offenses, now they're Class B, Class A, and revocation. So we put in some more prohibitive locations. We keep giving and we keep giving and we keep giving.
And Mr. Phelps, that's a terrific point, and that's exactly the point I wanted to bring up, is this has been something where there's been a compromise that's truly been worked upon. Ladies and gentlemen, to the bill, I want to tell you the Second Amendment of our Constitution gives you the right to bear arms. Not own arms, bear arms. And I want to talk to you about a Supreme Court case, which is Muscarello versus the United States in 1998. And I want to give you a quote from Justice Ginsburg from the Supreme Court. Surely a most familiar meaning is, as the Constitution's Second Amendment indicates, wear, bear, or carry upon the person. The Second Amendment gives you the right to bear arms. We in the state of Illinois currently are denying our citizens that right. We believe Justice Ginsburg is correct. I also want to give you some stats here real quick, and I want you to listen to these, because at first you may think I'm on the other side. Nationally, I want to tell you first, murder rates have gone down 50% in this country over the last 20 years. Murder rates have gone down 50% in the last 20 years. In 2012, there were 500 plus murders in the city of Chicago. 435 of those were committed with guns. In 2012, 319 students in from Chicago public schools were shot. 24 of those died. Ladies and gentlemen, since 2001, more than 2,000 U.S. troops have been killed in Afghanistan. Since 2001. At that same period of time, more than 5,000 people have been killed in the city of Chicago. Chicago's murder rate is quadruple New York's, and it's double that of Los Angeles. There's a very smart man known as Albert Einstein that said, the definition of insanity is doing the same thing over and over and over again and expecting different results. The gun laws in Chicago, the tight gun laws, do not work, and the statistics prove that. When the handgun ban was lifted in 2010, you know what happened in 2011? Homicide rates in Chicago went down 14%. Violent crimes went down 9%. And property crimes went down 1%. By the way, the source here is the Chicago PD and also the FBI Uniform Crime Report. I would also tell you the FBI Uniform Crime Report says, in states that concealed carry is implemented, there are 22% lower violent crime rates, 30% lower murder rates, 46% lower robbery rates, 12% lower aggravated assault rates. These are FBI statistics. We're under a court order to issue some reasonable form of concealed carry. I believe we have a very reasonable form of concealed carry in this bill. This bill sets one standard for people in the state of Illinois. It doesn't discriminate against citizens on any socioeconomic issues. I urge an aye vote, and I ask you to support the Second Amendment. Thank you.
Mr. Eunice for 5 minutes.
Thank you very much, Mr. Speaker. Will the sponsor yield?
Sponsor yields.
Representative Phelps, the language in this bill that relates to universities is the language that was agreed upon by them in a previous bill. Is that correct?
That is correct. And be honest with you, our side, we wanted pass-through. For example, let's take Representative Boston and myself, district, Southern Illinois University. State Route 51 goes between the campus. We feel that if you're in your car and you're doing a pass-through, that should be okay. So yes, this was agreed language from the previous bill, and we just want the pass-through language.
Thank you, Representative, and I want to thank you for working with them and working so diligently and so persistently on this bill and all the work that you have done on this bill. And Mr. Speaker, to the bill. This is a critical issue for law enforcement, not only in my district, but for law enforcement all across the state. Indeed, every single sheriff and countless numbers of police chiefs from my district are all proponents, all very supportive of this bill, and they tell me that they need the passage of this bill sooner rather than later. This bill incorporates all of the best practices of concealed carry states throughout the country. Now, I've talked to many or some opponents to this bill. And many of the opponents that I have talked to tell me that one of their fears is that with the passage of concealed carry in our state, that somehow our state would turn into the wild, wild west. And when I hear this, I instantly go back to them and say, have you ever been outside the state of Illinois? And if their answer is yes, I ask them if they were in the wild, wild west then. Because the fact of the matter is 49 other states have concealed carry. And if you've ever traveled outside of the state of Illinois, you've been in a state that has concealed carry, and very likely you probably didn't even notice. You probably didn't know. But the people that do notice are the criminals. And the reason we know that is because of what the previous speaker acknowledged. That when concealed carry is enacted, the data time and time again shows that the crime rate doesn't go up. Indeed, the crime rate goes down. This is a well-written, it's a very reasonable, and it's a public safety-minded piece of legislation that is long overdue. And I urge its passage. Thank you very much.
Representative Cassidy for 5 minutes.
Thank you, Mr. Speaker. Inquiry of the chair. How many votes are required for passage?
This bill preempts home rule, requires 71 votes.
And I'd like to request verification if it achieves that.
That request is acknowledged.
Many of the previous speakers have referenced yesterday's debate. And clearly, we do simply come at this from different perspectives. I agree that this bill in some ways is better than previous versions. There are other ways in which it isn't. One major concern, this bill widely expands the definition of a handgun. Under this bill, a person could freely carry a concealed handgun with an attachable high-capacity magazine and a laser sighting device. This is not something I would want to see on a CTA train in my district. The red line runs through my district, and this bill specifically prohibits or specifically allows that people can carry on mass transit. Anyone who has ever read red line, anyone who listened to the debate on the amendment that passed with 65 votes, has heard very clearly what our train and bus system is like, and what the impact of having armed people in that congested an environment could possibly be. Carrying in prohibited areas, there are a significant number of prohibited areas under the bill, but carrying in a prohibited area is a misdemeanor, regardless of how many times you do it, and nothing triggers revocation of a carry license, no matter how many times you willfully violate those prohibitions. Playgrounds. Everybody knows I talk about my kids a lot. Playgrounds are not exempted. Private owners can designate areas to be prohibited on their own property, except a commercial or residential private landlord cannot prohibit lessees from carrying and possessing firearms either within the building or while walking to and from the building. What we're saying here is it requires a private building owner, whether residential or commercial, to allow carrying firearms within their own property. For the first 10 years of my kids' lives, we lived in a 2-flat that we owned. We rented one of the units out. We shared common areas with our tenants, and I would have to allow my tenant to possess a firearm. I would not be able to prohibit carrying a firearm in my home. We referenced that nothing triggers revocation of a carry license and the minimal penalties for carrying in prohibited areas, but a home rule unit would be liable for all costs, fees, and damages, punitive and actual, to anyone impacted by a rule or ordinance related to firearm regulation. The application, which the sponsor talked about the fee, and it is a higher fee, and there are some clever, thoughtful ways that the fees will be distributed. However, the Illinois State Police says it costs at minimum $80 per license, whether it's the first time or the renewal. So from the very start, we will be running at a loss. The fee will not cover the costs of the program. Any Illinois resident with a carry license from another state can carry as of the effective date of the bill. No need to register with ISP or take the required training, even if your carry license comes from a state with less training requirements. Ultimately, this isn't soup yet. We all know that we are operating under this deadline. We all know that we come at this from different perspectives. I spoke yesterday very sincerely of my respect for the differences in our communities, and I am asking for that same respect. I grew up in an area where hunting is a very popular pastime. I respect that. I have all the respect in the world for the sponsor and the proponents of this bill. The only hunting that's happening in my neighborhood is of young men. More guns are not the answer to our gun problem in Chicago. Please, let's get to the table. Let's get a solution that respects the differences between our communities. There is a solution and there is time. This isn't soup yet. Vote no.
Mr. Meyer for 5 minutes.
Mr. Speaker, to the bill. I stand before you in strong support of conceal and carry. Law-abiding citizens have the right to protect their families and property from violent criminals. Where I live, farmers drive early in the morning and late at night, checking their fields and their ammonia anhydrous tanks. I am one of those farmers. Conceal and carry would offer protection against criminals trying to steal ammonia to make meth, and at the same time giving me the ability to protect myself. For the safety of the men and women in my district and in protection of our Second Amendment rights, I urge all members of the House to vote yes. Thank you.
Adam, member to each side of the aisle. The next speaker will be Representative Will Davis for 5 minutes.
Thank you, Mr. Speaker. Will the sponsor yield?
Gentleman yields.
Representative Phelps, as I've had some dialogue with you about this, of course you know for me that leaving duty to inform in this bill doesn't help me at all. We're clear on
we
that,
talked.
right?
You know, I know the last time we brought this up, you and I discussed this, and I know you said there was no language that could make this better, that you just wanted the duty to inform to be out. But the reason why we have so many law enforcement sponsors or proponents of this bill is because of duty to inform, because of their safety.
Okay, fair enough. So as I was trying to peruse the amendment, let me just try to ask a few questions. Does this amendment restrict the number of weapons an individual can carry at one time?
Say that again, Will. Sorry.
Does this amendment restrict the number of weapons that an individual can carry at one time?
No, it does not.
It not.
It does not.
So if you're talking about reasonableness with this, then why would you allow, I mean, an individual could feasibly carry 6, 7 weapons on their person. So again, if you're talking about reasonableness with that, why wouldn't we restrict the number of weapons an individual can carry?
These are individuals, remember now, these are individuals that have passed numerous background checks, that has the proper training,
Brandon,
and has a Ford card, so they're law-abiding gun owners.
So let me ask. So I'm ignorant to this. So can a law enforcement officer carry as many weapons on their person as they want to?
I believe so.
They can?
I think it's up to their bosses, I believe.
Do we know that for certain?
Most law enforcement. Representative Costello was a law enforcement official, and he says that yes, a lot of them have backup.
Well, I know they've got backup, so I know they carry, I guess, a primary and maybe have a backup on their ankle or something like that. So I'm talking about more than 2. They generally carry more than 2 weapons.
I don't know that, Representative Davis. I don't know that. I'm not an official or a police officer, but I think there's one in the car. There are multiple guns in their car, their trunk. They could have multiple. They could have 2 on each hip, 1 on their ankle. I'm not sure. But I think these are hypotheticals. I don't see where other states that have concealed carry this has ever been a problem.
Okay. So, all right, got it. So on in this section about restrictions, one thing that I want to be clear, it appears that an individual who may be able to carry is prohibited from carrying a weapon in our parking lot of Stratton building, but it doesn't prohibit me from allowing someone to come into my office with a weapon.
Yes.
My district office.
No, here's what we did, Representative. I know you're going to, this was big for me, and I think it would be big for a lot of us. My district office is in Harrisburg, Illinois. We put in the bill where it is up to the General Assembly member, you, to have the discretion if you want to allow concealed carry or not. It is up to each and every one of us. We thought that was the right thing to do.
That is not how I understand.
That is the intent of this. With this drafting, that is the intent, Representative, and I'm saying it on the record.
Well, I understand the intent. So you're saying that's the intent, but if it's different than what the language actually says.
I will be glad to do a trailer bill or technical amendment in the Senate, or we can do it right after this. But that is the intent and the agreement that we had, that it's up to each. You can't bring it in government buildings, but we can put it in the parking lots, because we think we should allow the law-abiding gun owner to be able to safely store his or her concealed carry weapon in their car, glove box, trunk, things like that.
Well, I'm clear, and let me just read. It says, except that nothing in this section shall prevent a member of the General Assembly from allowing licensees to carry a firearm into his or her district office. I'm reading the language.
And we're saying, like I said, that might be in there, but the intent, and I will do a change, that we want to leave it up to the discretion of the legislator, only in the district office. Because you can't bring it in the Stratton building anyway, because it's a government building.
Correct. So, as my time is running out, can you tell me why there's such a difference between a school and a library? Because the language says that a school, you just have to notify the appropriate personnel or receive authorization from personnel, and then that authorization or that personnel would then have to then inform the local law enforcement. But with the library, you have to get authorization from that governing board to be able to walk into a library. And then the board's responsibility then would be to notify law enforcement. Why is there such a difference between school and library in that case? And then also, what about a library that's in a school?
It's the consent of school authorities, Representative Davis.
Right, consent of school authorities. But a library, it says you have to get consent of a board, the governing board. Why is there such a difference between schools and libraries?
The library is governed by maybe the city, Representative Davis. I mean, you know, so we just think it should be up to their discretion, and basically those are prohibitive locations. Matter of fact, Representative Davis, this is a lot of people don't really want to hear this, but this is probably the strictest shall issue bill in the country.
Representative Davis,
right now.
Could you bring your remarks to a close?
Absolutely, absolutely. Well, just briefly to the bill, Mr. Speaker, and as I've stated before, I understand that we have to embrace something that the courts have required us to do. And I think it's always been the intent of members, particularly from this side of the aisle, to talk about where we think there should be restrictions on this. Restrictions. Now, whatever the court said, and I didn't read the opinion, it doesn't mean that you just have to open it up for any and everybody to be able to go anywhere they want to go carrying a weapon. I don't think that that was the intent of the court's decision. It just simply said that you have to be able to have a concealed carry law in the state. So again, in our efforts to try to embrace what the representative wants to do, I just think that this is going way too far, way too far. And I hate to say it, but unfortunately, I think this will actually get worse in our state before it ever gets better. Many of you will probably argue that now I'm able to protect my family, you know, I feel safer, and I understand. I understand, but one of the things that we try to mitigate here are the issues that we have, unfortunately, in the city of Chicago. So when you take this and overlay it into the city of Chicago, I think you're going to have more incidences that are going to happen when this becomes law than anyone would ever imagine. And I hope that we're prepared. As a matter of fact, I hope that we're willing to stand up and give moments of silence to all the individuals that are probably going to get harmed as a result of this kind of very open, abridged, if you will, conceal and carry that we're going to have here in the state of Illinois. I appreciate all the sponsors' work, everything that he's attempted to do. And again, as this bill moves over to the Senate, I hope that we'll be able to continue to have dialogue and offer some ways in which to restrict this. We need to restrict this, ladies and gentlemen. It should not just be open-ended the way it is now. Thank you.
Thank you, Speaker. Ladies and gentlemen of the House, I rise in support of the gentleman's legislation. And over the past 20 years, it's been very rare that we have had the opportunity to vote on third reading on a bill which is supported by the Illinois State Rifle Association, by the National Rifle Association, which has been negotiated and gone through some very heavy and important changes in the course of the last few days. I commend the sponsor, also Representative Bost and Sullivan, Representative Bradley, for their work on this issue. In the course of the last 4 weeks, we have heard gun bills and 40, 50, 60 separate amendments, all talking about some of the differences between the different regions of the state of Illinois and what should be included, what should be excluded. Representative Phelps has taken much of the language from the bills that all of us have voted for in one form or another and placed them in his legislation in 997. The idea being to create a common sense rule for the state of Illinois. Now, the courts have come down and they have said that we have to make a decision and to address a situation where the clock is ticking. In the beginning of June, then we will be back at the court with the stay. We will have a potential for open carry. Whether you are a supporter of the Phelps bill or some of the City of Chicago bills, no one wants an open carry situation. In the course of all the bills that we talked about, we said there needed to be a mental health component. There is a mental health background check component. It is comprised in the fees that were structured by Representative Phelps. It costs $18 to get the background check. There's $30 in there to administer it and purchase the background check. There is $70 which is in that fee, and that is to help process and make sure the cards can actually be done. We need to work together as a body to address what the court has said has to be done. We don't want to get to that point or get over the cliff. The Cook County State's Attorney, her senior staff came to our hearing and said on the 7th of June he would still enforce Ag UUW statutes as he is doing now. In saying that, it's almost like he said the federal courts are advisory only. Well, ladies and gentlemen, we have two previous governors that will tell you the federal courts are not advisory only. We have to take an action, and I think this is a common sense, solid bill which contains almost every one of the prohibited areas that both sides said should be under consideration. It has training at twice the level of the original bill, and it has recognized courses that can be designed and structured by the state police for approval and have range time. We need to take an action. We need to do something that will put us in compliance with the courts, but also make sense for the people who live in the city of Chicago, as well as Cairo and the rest of downstate, or Cairo for those of you from Cairo. Okay. So I would rise in support. I want to thank the folks who have worked together to put together a meaningful, sensible bill that meets the requirements of the courts, and that's what's lacking in the other bills that we saw. It does not meet that requirement, and it puts all of our areas at risk. So to those that said they would vote for this and keep it moving forward, I would hope that you would keep to your word, keep working with us, and let us continue on to get a fair, decent law that works for all the people of the state of Illinois. Vote yes.
We didn't throw this together overnight. This is over decades of people trying to run something. But now it's different. We have a court order that we must deal with. To some of the points on the crime, let's begin there. As we know, and I think a lot of people cannot deny this, Chicago and Cook County have the strictest gun laws in the country, but lead in the most shootings and the most murders in the country because the criminals know they don't fear retaliation. That's why I don't think there's anything wrong with you being able to protect yourself and your family, because most of the shootings are happening on the streets, not in the homes. FBI Uniform Crime Report again. Let's go over this again. 22% states have concealed carry. 22% decrease in violent crime. 30% decrease in murder rates. 46% decrease in robberies. 12% it's a decrease in aggravated assault cases. I think the proof is right there. And by the way, if it's so scary, why hasn't there been one other state in this country repeal concealed carry? Because it works. And we really know it does down deep. And down deep, you know your constituents want this and they need this. For the first time ever, we're trying to fix the mental health reporting fiasco that we have. It's in here, and it's only going to get better. A lot of you said last time that if you brought 148 back up on the floor, you would pass it. Well, this is better than 148. And if we don't get something done because of the court mandate, Constitution carry sets in on June the 9th. Now, we've talked about the Wild Wild West. That, my friends, will be the Wild Wild West if we go off the cliff June the 9th. I urge an aye vote. We know the right thing to do. We have to do this. And ladies and gentlemen, this may be our last chance. Our last chance to get something reasonable done. I urge an aye vote.
Ladies and gentlemen, two things from the chair. First, this bill requires 71 votes. Second, Representative Cassidy has requested a verification. Please vote your own switches and be in your chairs. All those in favor of the gentleman's bill will vote yes. Opposed, no. The voting is open. Have all voted who wish? Have all voted who wish? Have all voted who wish? Mr. Clerk, please take the record on this question. There are 64 voting yes, 45 voting no, and 4 voting present. Mr. Phelps.
I ask for postponed consideration.
Will be placed on the order of postponed consideration.
The Illinois Channel's coverage of legislative issues is underwritten in part by AARP Illinois.